This is part 30. In this part, we shall be dealing with section 309 of the Indian Penal Code, which defines the offence of attempt to commit suicide. But before that, this is also the time for me to remind you that follow the instructions that are given by me so that your understanding of the subject becomes very clear. Now, when we were dealing with section 304B of the Indian Penal Code, which defines the offence of dowry death, I had drawn your attention to section 113B of the Indian Evidence Act. So now, this is a time when I refer to some of the sections as far as the Indian Evidence Act is concerned. You must be in a position to refer to that section. Not only that section, refer to the chapter. And then, as you start reading the same during course of time, you will start learning yourself. And as a student of law, never wait for your teacher or somebody to tell you something. You start doing of your own, and if you start finding out, asking yourself question why and try to find out the answer, this is the method in which you can have what is known as holistic approach and or learning law in totality, which is very important. Now, at the time of discussing section, I read out, if you remember, section 113B, and there I said section 113B, the last part, if you refer to, the court shall presume that such person had caused the dowry death. The court shall presume. Now you must be curious as to what is this shall presume. And in order to understand this, as you start learning, right from section 1 up to section 4, section 167 as far as Indian Evidence Act of 1872 is concerned, you refer to section 4. And then you come across definition. Section 4 says may presume, and it says whenever it is provided by this act that court may presume a fact, it may either regard such fact as proved unless and until it is disproved, or may call for the proof of it. This is what do you mean by may presume. Now here we are concerned with shall presume, and next part of the section says what do you mean by shall presume, how that has been defined. Whenever it is directed by this act that the court shall presume a fact, it shall regard such fact as proved unless and until it is disproved. So it is court shall regard such fact as proved unless and until it is disproved. And the last part of the section deals with conclusive proof, which says when one fact is declared by this act to be conclusive proof of another, the court shall, on the proof of one fact, regard the other as proved and shall not allow evidence to be given for the purpose of disproving it. And hence, as you start learning section 4 or understanding section 4 during course of time, this can be understood by you provided you know certain terms. And which are those terms? What do you mean by proved? What do you mean by not disproved? And what do you mean by not proved? For that, you will have to refer to, as usual, section 2, section 3, which is here interpretation clause, where you come to know what do you mean by court, what do you mean by fact, what do you mean by relevant, what do you mean by fact in issue, what do you mean by document, what do you mean by evidence, and rest of the things. So this should be your approach from the point of view of learning law, and then only it is possible to understand the law in the manner in which I want you to learn the law. Now, when we were dealing with section, this is regarding section 304B, but when we were dealing with section 304A of the Indian Penal Code, which deals with the death is the result because of rashness or because of the negligence. And during course of time, if you remember, I had told you that we will work out details at the time when we deal with general exceptions, especially when the doctor is protected. What do you mean by accident as a defense, with which we shall come across few more illustrations, no doubt about it. But now this is also the time for me to tell you that higher degree of rashness or negligence is required to constitute liability as far as Indian Penal Code is concerned. But if the person was negligent and that negligence has resulted into injury to somebody, he can proceed, such a person can proceed against him as far as the civil court is concerned and sue for what is known as unliquidated damages as per law of torts. So this is also one more hint which I want to give you, that when you are dealing with negligence, yes, negligence is one topic as far as law of torts is concerned, also have reference to that. So what do you mean by negligence? I mean, during course of time, as you start reading the same, your understanding regarding the topic becomes very clear. Medical negligence is such a vast subject. During course of time, you will find out that when we talk about medical negligence, it may be, as per the provisions of the Indian Penal Code, or it may be liability, may be as far as law of torts is concerned, where as it is civil remedy, the only remedy that is available to you is to sue for unliquidated damages, and there, for example, this should be the approach for the purpose of understanding the same. With this now, I draw your attention and start discussing section 309 of the Indian Penal Code. And the most important part of this section is that here what is made punishable? Attempt to commit suicide is made punishable. What do you mean by suicide? Homicide is killing of human being by human being. But if you kill yourself, one person kills himself, this is what is known as suicide. And as per the provisions of the law, whoever attempts to commit suicide and does any act towards the commission of such offence shall be punished with simple imprisonment for term which may extend to 1 year, or with fine, or with both. So the only offence, if you cross, if attempt is successful, and if you are not in this world, naturally the question of liability doesn't arise. So what is the punishment is for what? Punishment for attempt to commit suicide. So that is one thing of which you have to take note. The only section, you will say, sir, you have referred to some of the sections at the time when you discussed stages regarding commission of an offence, where namely intention, preparation, attempt and commission, where the attempt is also made punishable. Yes, attempt is made punishable as far as section 511 is concerned. Yes, attempt is made punishable as far as section 307 is concerned. 308 is concerned, 393 is concerned. There are some sections where express provision for attempt to commit an offence is also made. But then when there is no express provision as far as attempt to commit an offence is concerned, for which the punishment is laid down, to know the quantum of the punishment that can be inflicted by the court of law, as we have dealt in the past, you have to always refer to section 511 to know the quantum of the punishment that can be inflicted by the court of law. But there, for example, A wanted to commit theft and he was unsuccessful, he can be convicted as per section 511 to be read with any one of the sections right from section 379 up to 382, which are the section. But if the attempt would have been successful, his liability would have been not as per section 511 but would have been as per section 379, 380, 381 or 382. But in case of attempt to commit suicide, the only offence, if you become successful, the question of liability of an individual doesn't arise, and hence what is made punishable? Attempt to commit suicide, namely attempt itself is an offence which is made punishable as far as section 309 of the Indian Penal Code is concerned. Now this is the time where it is a must for you to refresh your memory regarding whenever somebody wants to commit an offence, he has to undergo various stages, namely intention, 2 preparation, 3 attempt, and then if the attempt is successful, we say person is liable for commission of an offence. If the attempt is not successful, then we say is liable for attempt to commit an offence, which is also an offence and hence made punishable by the provisions of the Indian Penal Code with which you are dealt. Now this is, this takes me back to the illustration, if you remember, when a lady wanted to end her life by jumping into the well and she started running into the direction of the well. She was caught by the neighbor when she was at the distance between the door and the well was 100 feet. She was caught hold by the neighbor when she was at a distance of 50 feet. She was caught hold by the neighbor when she was at a distance of 2 feet. She was standing on the footpath of the well and she was caught hold by the neighbor. She was about to jump into the well. She was caught hold by the neighbor and taken to the police station. And lastly, she jumps into the well. Neighbor also jumps into the well, takes her out and takes her to the first of all medical end and then to the police station so that to proceed against her for the offence as defined by section 309 of the Indian Penal Code. What is her liability? Now, mind well one thing, that as long as person is undergoing stage of intention, the question of liability doesn't arise. When he is undergoing stage of preparation, barring few preparations to which I have made mention, just refresh your memory, section 122, section 126, section 399, where the preparation is also made punishable. But otherwise, in case of intention and preparation, as there is every chance or possibility for you to withdraw, the question of liability doesn't arise as per the provisions of the Indian Penal Code, and then you cross the stage of preparation and enter the stage of what is known as an attempt. And there we are learned what is this attempt. It is a direct act towards commission of an offence. Whatever is required to be done on the part of an individual, if it is done by him, and he has reached such a stage that he may be sorry for the consequences which are likely to take place, there is no chance or possibility for him to withdraw. And now he is unsuccessful because of the circumstances which are beyond his control. This is exactly the stage we say where he has, and this stage will depend upon the nature of the offence. For example, a man wanted to end his life by consuming poison. He had poured poison from the bottle to the glass and kept it ready, but then he was thinking whether what was his state of the mind, to be or not to be. First of all, he thought, if I commit suicide, everybody will start blaming my wife. So he said, he had written very clear note that my wife is not responsible as far as ending of my life is concerned. Then again when he was about to, he thought, shall I consume poison? But no, he thought that everybody will start blaming my daughters, or everybody will start blaming my son. So he wrote, no, what is this? And in the meantime, it so happens that unfortunately for him, and fortunately for us, police enter the room and they take a glass which is full of poison and they want to proceed against him. What is his liability? He has not crossed the stage of preparation. There is every chance or possibility for him to withdraw, and hence the question of liability doesn't arise. As in case of attempt to commit suicide with respect to the woman who wanted to end her life by jumping into the well, standing on the platform, she can withdraw. At a distance of 2 feet, she can withdraw. At a distance of 50 feet, she can withdraw. When she is about to jump into the well, that is exactly the stage where we say, if their neighbor would not have caught hold of her, she would have definitely, achieved the goal or the object. And hence what we say, this is exactly, it's not necessary for her to jump into the well. For example, a man has a glass full of poison, and he is sitting and he is about to take a sip. Before he takes a sip, a ceiling fan falls down. Now, as a human being, you must appreciate and understand that anything is possible in this world. So instead of he consuming a glass of poison, that is spread everywhere on the floor, what is his liability? He wanted to end his life, he wanted to commit the offence as defined by section 309. There was the preparation, he had crossed the stage of the preparation, but why he was successful? He was successful because he was not successful because the ceiling fan fallen on the glass itself, had fallen on the glass itself, or maybe the cat directly jumps into the direction of the glass, as a result of which it is not possible for him to consume. So there are ways and means in which a person can end his life, but then whatever is done by him, it must be a direct act towards commission, and he must, and that is coupled with what? Mens rea is always coupled with the actus reus. Tomorrow, if somebody takes a glass full of water and says, I will now consume this and I will end my life, He may have mens rea, no doubt about it. But what is actus reus? Actus reus means such a result of the human conduct that law seeks to prevent. Now, nobody prevents you from consuming a glass of water, and hence the question of liability doesn't arise. There are, this is also the time for me to tell you that if time permits, during course of time, I may go on giving you n number of illustrations. And which are those illustrations? Generally, I tell the students, my dear students, in order to understand IPC, you may read the book, no doubt about it. But by reading the newspaper also, you can understand the provisions of the Indian Penal Code. And then this is the time where if person ends his life, what is the manner in which he has ended his life? You read in the newspaper n number of ways. There is also one way whereby person can end his life, and if he has decided to be he proceeds on starving, fasting unto death. Yes, that is also the case. But which is the stage at which it can? First day of starvation, second day of starvation, third day of starvation, fourth day of starvation. Now mind well, this is only preparation, because there is every chance or possibility for him to change his mind. The stage depending upon an individual. In one case it may be 20 days, it may be 30 days, in one third case it may be 40 days. Which is the stage? The day at which, because of the starvation, is about to collapse. And this is starvation act also includes illegal omission. When you want to live in this world, you must eat the food, you must eat food. And then if you don't eat, mind well, that is what is known as an illegal omission on the part of an individual, if it results into death. And here, if it results into death, the question of liability doesn't arise, but he reaches such a stage at which there is every chance or possibility for him to end his life, or his life would have been ended. Then that is exactly the stage at which we say this will depend upon facts of the particular case. And hence, as a student of law, remember one thing forever, that in the Evidence Act, proof is very important from the point of proving something in a court of law. What is the nature of the evidence with which you shall be dealing? There may be a direct evidence, there may be a circumstantial evidence, yes, what is known as indirect evidence, but this is what is required to be required. As far as here we are not disputing the facts, we take it for granted, and we always take into consideration extreme cases. A man wanted to end his life by hanging himself to the ceiling fan, because of which he has tied a rope. He had made a head. He had put table on which there was a chair. He was standing on the chair, and he was about to put his neck into the head and then kick the chair so that his death may take because of the strangulation. As he was standing there, all of a sudden, his neighbor came and caught hold of him and never allowed him to end his life. What is the stage? It is just stage of preparation. Because by merely looking at the ceiling fan to which the rope is tied, you can't end your life, mind well. So you want to end your life by jumping across the running rail, and you stand by the side of the rail. It cannot be said that you are liable. So there are various cases that illustrations that can be taken into consideration for the purpose of understanding. But then, if a person wanted to end his life, as when we talk about today, the law which stands today as far as Indian Penal Code is concerned in the year 2012 is that attempt to commit suicide is an offense. And hence, now when there is attempt on the part of somebody, nobody, as you have got no right to take anybody's life, similarly you can't take your life also, because you are part and parcel as far as the society is concerned. And hence this is made punishable as far as section 309 of the Indian Penal Code is concerned. But then this is all right. You write down intention, preparation, attempt, and the person is unsuccessful as far as his attempt is concerned, and hence he can be proceeded against and convicted as per section 309 of the Indian Penal Code. But now, as a student of law, you must remember one thing, that this law relating to attempt to commit suicide has undergone a change. The law as laid down by the Supreme Court in Gyan Kaur versus State of Punjab, which was decided by the Supreme Court in the year 1996, and that is, it is because of this now today we have, this is an offence as per section 303, 309. But then if you go back to section 1990, go back to the year 1994, in P. Ratinam's case, it was held by the Supreme Court that attempt to commit suicide is not an offence. This section was struck down by the Supreme Court in P. Ratinam's case, and there, for example, it was discussed that, well, this is, when you refer to fundamental rights, positive part of the right also includes the negative part of it. And if you read section 21 of the Constitution of India, which says no person shall be deprived of his life or personal liberty except according to the procedure established by law, Article 21 speaks about right to life. That is the positive part of it. But what is the negative part of it? The negative part of it is right to die. As when we deal with Article 19, subclause 1, where we take into consideration a right to move anywhere, it includes right not to move, freedom of speech and expression. You have got right to speak, but that does not mean you can be compelled. You can say, well, I don't want to speak. That positive part of the right also includes the negative, and hence that was the argument that was advanced at that particular time, and hence Supreme Court had held that yes, right to life also includes right to die. And hence in P. Ratilam's case, as Supreme Court had recognized the negative part of the right, namely right to life also includes right to die, that was not an offence from 1994 onwards. Prior to that, there were many decisions which were given by various high courts. Now, it may not be possible for me to go through all the decisions, but I can refer to one decision, namely Maruti Sripati Dubal versus State of Maharashtra, which was decided by Mumbai High Court in the year 1987, as per which it was held by the Honorable Court that attempt to commit suicide is not at all an offence. If somebody, when he has got right to live in this world, he can take a decision not to live in this world and he can end his life. That was what was, if the person doesn't want to live in this world, how he can be compelled? And hence, that was what was decided by, when the law is declared by High Court, that becomes law of the particular state. When the law is declared by the Supreme Court as per Article 141 of the Constitution of India, that becomes law of the land. So, this, there were many decisions which were given by various high courts as and when it is necessary and possible. You can go through that, no doubt about it. But, remember the situation as far as the state of Maharashtra is concerned. From 1860 up to 1987, attempt to commit suicide was an offence. But as it was held in Maruti Sripati Dubal versus State of Maharashtra as far as Mumbai High Court is concerned, where the section was struck down. From 1987 onwards, attempt to commit suicide was not an offence in the state of Maharashtra. But if somebody would have crossed the boundary marks of state of Maharashtra and entered any other state, that was an offence, because the decision which is given by one high court is binding on courts which are subordinate to that particular high court, and not courts which are subordinate to another high court. Yes. As this matter went to the Supreme Court, and it was held by the Supreme Court in P. Ratilam's case. The decision that was given by the High Court, namely the attempt to commit suicide is not an offence, was upheld by the Supreme Court, and from 1994 onwards, attempt to commit suicide was not an offence. But then Supreme Court has got one power of what is known as prospective overruling. The decision given by the Supreme Court can be overruled by the Supreme Court. And hence, if attempt to commit suicide is not an offence, the two sections, I mean if you refer to two sections, namely 305, which deals with abetment of suicide of child or insane person, or abetment of suicide as laid down by section 306. If attempt to commit suicide is not an offence, whether abetment of suicide should be an offence was the question. An entire law relating to suicide was reviewed by the Supreme Court in Gyan Kaur versus State of Punjab, and the judgment runs into n number of pages. But what is the crux of it? The ratio which was laid down by the Supreme Court was that, yes, we also agree that right to life also includes right to die. Yes, anybody, I mean one who anybody can die. But that was qualified by the Supreme Court by saying you can end your life, but the manner in which you can end your life must be a natural death. You can't end your life. Many arguments, I mean this is a debatable question all over the world. There are some countries where they allow you to end your life, no doubt about it. I mean there are countries, no, this is not the time for us to have, as a student you can have comparative study also. But as we are dealing with the provisions of the Indian Penal Code, we can't, I mean along with the Indian Penal Code, the time may not permit us to go through the laws that are laid down as far as the rest of the countries are concerned. But here, as laid down by, so this law was laid down by the Supreme Court in Gyan Kaur versus State of Punjab, which was decided by the Supreme Court in the year 1996, and today also, attempt to commit suicide is an offence. Now, what was challenged in that case? If attempt to commit suicide is not an offence, abetment of suicide should not be also not an offence. And that is exactly, I mean, what was, I mean, discussed by the Supreme Court during course of, I mean, judgment as far as this Gyan Kaur versus State of Punjab is concerned. And hence now, when we talk about abetment, I hope you are not forgotten. We have dealt with what? We have dealt right from section 107 up to 120 by taking into consideration abetment of an offence, where we are learned abetment is not an offence, but abetment of an offence is an offence. And then this is also the time for me to draw your attention as to one more section as far as Indian Evidence Act is concerned, and that is, if you refer to section 113A, which was an amendment to the Indian Evidence Act in the year 1983, it speaks about what? Presumption as to abetment of suicide by a married woman. At times, suicide is committed by a married woman, and the section says, when the question is whether the commission of suicide by a woman had been abated by her husband or any relative of her husband, and it is shown that she had committed suicide within a period of 7 years from the date of her marriage, and that her husband or such relative of her husband had subjected her to cruelty, the court may presume, having regard to all other circumstances of the case, that such suicide had been abated by her husband or by such a relative of her husband. So court may. Now I had drawn your attention as far as this part of lecture is concerned, where I told you what do you mean by may presume, what do you mean by shall presume, what do you mean by conclusive proof. But then if you read section 130, and this was, I mean, let me tell you, there were some amendments to the Indian Penal Code in the year 1983. One amendment was 400, the section with which we dealt when we dealt with section 304B, namely 498A of the Indian Penal Code, along with the Indian Evidence Act was amended as far as section 113A is concerned. 304B, dowry death, was an amendment to the Indian Penal Code in the year 1986. And then to understand this, along with this you have to read section 113B, presumption as to dowry death as far as the Indian Evidence Act is concerned. So, and then during course of time when we shall be discussing section 375 of the Indian Penal Code, I will draw your attention to section 114A of this chapter of the Indian Evidence Act, which deals with presumptions as to absence of consent in certain prosecution for rape, with which we shall be dealing during course of time. But then this is the time when we talk about, generally I had told you that by reading the illustrations you can learn the law, you can understand the law. But mind well, as a student of law, when law has undergone a change, maybe because of the decision that is given by the High Court, namely Maruti Sripati Dubal versus State of Maharashtra, a decision given by the High Court can be overruled by the Supreme Court. A decision given by the Supreme Court can be overruled by the Supreme Court. But mind well, a decision given by the Supreme Court cannot be overruled by the High Court, because High Court is subordinate to the Supreme Court. And hence now, during course of time, go on learning the principles that I have told you. And for the purpose of learning the principles that I have told you, this is learning of law. And mind well, this learning of law should be forever. You should always remember one thing, that you should continue yourself. Learning process must continue forever. You must be a student forever. So that is as far as section 309, for which I had drawn your attention to certain extent as far as section 305 and section 306 is concerned, to be read with section 113A, to be read with what? To be read with section 4 of the Indian Evidence Act. It's not that you should immediately start, understanding everything. It may not be possible. You are bound to take your own time. But unless you have this approach, and then as a student of law, as I have told you in the past, as you must have Bare Act with you, not only of the Indian Penal Code, but while learning Indian Penal Code, there may be references to various enactments. So it may be possible for you to have a book or not textbook, but at least a Bare Act, so that you can have ready reference, and by reading the section also it becomes very easy for you to understand. So now we have dealt with this is section 309 of the Indian Penal Code, where it is must for you to make mention of the case law. In the absence of case law, the law relating to attempt to commit suicide. Today, yes, we have this law, namely attempt to commit suicide. A section 309 you have to read and implement as it is, no doubt about it. With this now, once we start dealing right from section 312 up to section 318, these are the offences relating to causing miscarriage, of the causing of miscarriage, of injuries to unborn children, of the exposure of infants, and of the concealment of births are the sections. From my point of view, at present I don't think it is necessary for me to go through all the sections, because you read the section and you shall be in a position to understand the sections accordingly. So there are many more sections where something is required to be explained, and hence what we will do, we will for the time being, if time permits and if I think, I may go through this part, but otherwise I don't think. You just read, and that the same section defines an offense and it also lays down the punishment which serve the purpose. From the as you read, you can and mind well, when I say read, do analyze, carry out dissection, try to find out ingredient, but follow this practice so that it becomes very easy for you to understand. With this now, we intend to start with two more sections, and that is section 339 of the Indian Penal Code, which defines the offence of wrongful restraint, and section 340, which defines the offence of wrongful confinement. Right from section 341 up to 348 are the sections which deal with punishment. Who has committed the offence, whether it is offence of wrongful confinement or whether it is offence of wrongful restraint, under what circumstances the offence has taken place, will be taken into consideration by the court of law in order to determine the quantum of the punishment that can be inflicted by the court of law. Yes, very correct. So we shall be concentrating on this section, but there in both the sections you will understand one thing, that both the sections deal with personal liberty. Wrongful confinement is, and I mean, if somebody asks you a question, what is wrongful confinement? Do make it very clear. Wrongful confinement is an aggravated form of wrongful restraint, and unless you know what is wrongful restraint, which is defined by section 339 of the Indian Penal Code, it may not be possible for you to explain and understand section 340 of the Indian Penal Code, which defines the offence of wrongful confinement. Generally, I start discussion by giving an illustration that A climbs a roof with the help of the ladder and B takes away the ladder. What is liability of Mr. B? Now he has, there is no bodily harm, no, certainly not. But then he has done something which he ought not to have done, because of which what he has done, he has failed in his duty and there starts his liability. But whether this liability is for the offence of wrongful restraint, or whether this offence, the liability is for the offence of wrongful confinement, with which and rest of the part with which we will continue our discussion as far as next part is concerned.